My name is John McIntyre and I work for Local Government Risk Management Services. Today we're going to talk about workplace harassment for supervisors. Workplace harassment, workplace discrimination has been around for years and years, but legal actions mostly have been within the private sector. Now local government in the state of Georgia is under fire. Cases are escalating and they're very severe. Employees, they're more educated now. They understand the law. And we have a much more diverse workforce, and it's getting more and more diverse as time goes on. The way we act, the way we talk is under incredible scrutiny. What we used to do, how we talked, the actions we took now gets us in trouble. Supervisors themselves can be held personally liable for not following the rules and the guidelines set forth by federal law. Today, some of the things the supervisors are going to be required to know and do per federal law with regards to workplace harassment. Employers must control unrestricted use of electronic communications and the internet. Workplace harassment claims frequently involve this issue. That includes texting, Facebook, Twitter, instant messaging, social networking. Employers must maintain an effective electronics communication policy. There are some elements of an effective email policy. And the first one is to make sure you have a policy statement that states exactly what you want the policy to state. You should also have no expectation of privacy. That should be in the statement. All these things that we have are all subject to Public Records, the Open Records Act. The policy should state the acceptable uses of your electronic media policy. Also be very specific about the unacceptable uses. We can also set guidelines and procedures on how you can use the internet and electronic procedures. Also, you should talk about the use of computer software licenses and the legal and illegal parts of that. One of the key mistakes an employer makes is failing to train employees under the anti-harassment policy. Simply having a policy is not enough. It's not that you had a policy many years ago, but that policy is changing all the time. Employees must know what sort of conduct they cannot engage in, and they must know what they have to do and what they don't have to put up with. Employees must know how to report harassment. Another key mistake is failing to train managers and supervisors regarding their responsibilities under the anti-harassment policy. Supervisors are the key to successful implementation of any such policy, and non-compliance by managers and supervisors is more likely to lead to liability. Ensure that you document all anti-harassment training. You'll not get credit for it if you cannot prove you did it. There's a 7-year retention requirement for training records under the Georgia state law. Employers and supervisors must regularly remind employees of the anti-harassment policy. Take advantage of every opportunity. Use internal newsletters, meetings, postings, tailgate meetings, however you want to do it. This is a common practice of successful defendants. You must have multiple avenues for reporting alleged harassment. This is the key to having an effective reporting procedure. Employees should be permitted to bypass the normal chain of command. You need to have at least 2 or 3 different people at least for a claim to be reported to. If not, the EEOC will consider that a self-defeating policy. Supervisors must require their employees to report harassment even if it is not directed directly at them. Managers and supervisors cannot be everywhere. Make your subordinates act as your eyes and ears. But sometimes victims are sometimes very reluctant to complain. Failing to warn alleged harasser against retaliation. It's human nature to want to confront your accusers. Permitting alleged harassment by allowing confrontation by the accused can create retaliation liability, even if the alleged harassment would have resulted in a non-harassment situation. Retaliation is illegal. Whether it was true or not, it is illegal. Management cannot tolerate harassment of employees by non-employees. Employers have an obligation by federal law to rid harassment in the workplace, regardless of the source. It could be a vendor, it could be an arrestee, it could be a contractor, it could be an elected official, it could be somebody coming in to pay one of the bills, a water bill. Always act on anonymous complaints. They may have a lower degree of credibility, but they still can trigger your obligation to investigate. Those anonymous complaints, make sure you put down the date, the time, and what action you took. You can have no requirement that complaints be in writing or recorded. Even oral complaints still trigger the employer's obligation to investigate. You cannot require that a complaint be in writing or recorded, but it is best practice. Supervisors must take action against alleged harassers, co-workers who retaliate. It's human nature to come to a friend's defense. Retaliation cannot be tolerated regardless of who engages in it. There is a warning, though, that current state of law does not allow employees to retain an employee who is unwilling or unable to comply with the anti-harassment, anti-retaliation policy. You can never promise absolute confidentiality. This promise can rarely be kept due to due process, sunshine laws, disclosures, whatever. It's critical to manage the expectations of the complainant and their witnesses and keep them informed on a regular basis. The only thing you really can promise is that you will be fair and truthful in the investigation. Never allow untrained employees to conduct the investigation. Improperly conducted investigation can actually increase your exposure and your liability. Supervisors must react promptly to complaints or reports of workplace harassment. The most difficult harassment case to defend is the one where the harassment continued even after it being reported to management. Attorneys will tell you that this is a case that is almost impossible to win. Always remember, the alleged harasser has rights too. Lawsuits by employees accused of workplace harassment are on the rise. Do not limit your anti-harassment policy strictly to sexual harassment. A proper policy covers all forms of unlawful harassment or discrimination, notwithstanding the prevalence and uniqueness of sexual harassment, that is age, religion, national origin, disability, etc. Sexual harassment is sex discrimination that violates Title VII of the Civil Rights Act of 1964, and it prohibits harassment or discrimination of an employee based on age, religion, sex, national origin, disability. This is overseen by a federal agency called the EEOC, the Equal Employment Opportunity Commission. The EEOC sets guidelines on discrimination because of sex, and they were established and confirmed by case law starting in 1986. The EEOC enforces federal laws prohibiting employment discrimination on the basis of age, race, color, religion, sex, national origin, or physical disability. And their jurisdiction encompasses discrimination over everyone, private business, local businesses, whatever. They process charges of employment discrimination. They file discrimination suits on behalf of the aggrieved employees. The EEOC's main job is to provide information and guidance to help employers create fair workplaces. Sexual harassment. What does it mean to me, the employee? Well, it's federal. You have to be able to raise your right hand and swear in a federal court, not a magistrate, a local court, but a federal court. Every action, every conversation, every written command, every electronic communication, that includes cell phones, emails, they're all going to be looked at. The EEOC looks at the record as a whole, the totality of the circumstances. Determinations or findings on the allegations are based on facts, case by case, based on preponderance of evidence, not reasonable doubt, like criminal law. This is civil law. It is based on preponderance of evidence. Here's the definition, the EEOC's definition of sexual harassment. Unwelcome. Note that's in red because that's the key word. It's unwelcome sexual advances, requests for sexual favors, and or other physical contact of a sexual nature that has the purpose or effect of interfering with an individual's work performance, or it creates a hostile or offensive work environment. Unwelcome means unwelcome from the victim. They don't solicit, they don't ask for something, they don't incite it, they don't urge it, spur it on. They consider something very undesirable or offensive. But this is a slippery slope. Circumstances are not always the same. What affects one person does not affect another person. People do not always reveal whether they consider certain conduct to be unwelcome. Just because they go along with it does not mean it is welcome. And very importantly, the alleged harasser's intent is totally irrelevant. It makes no difference, per the law, whether you intend to hurt someone or it is accidental or you're just joking. It's still illegal. The victim or the harasser may be a man or a woman. It does not have to be the opposite sex. The harasser can almost be anybody. It can be a manager. It can be a co-worker. It can be an agent. It can be a contractor. It can be a non-employee. Unintended victims can still be victims. Anyone who is affected by what's going on in the workplace, whether it's directed at that person or not. How do we eliminate workplace harassment? There's one strategy that is the strongest and most effective way to use to help eliminate workplace harassment. The best response is to nip it in the bud. Prevention is the best tool to eliminate workplace harassment, and you want to eliminate it in the workplace. Stop the action early on. The best response is always to directly inform the harasser that the conduct is unwelcome and must stop. However, that doesn't always stop. If it doesn't stop and it keeps going on, use the available complaint reporting system. There are two types of sexual harassment. The first is quid pro quo, or now known as economic harassment, and it's usually a supervisor-subordinate relationship. The second is a hostile work environment. It's an unwelcome sexual conduct is so pervasive that it interferes with the employee's work performance or creates an intimidating, hostile, humiliating, or sexually offensive work environment. Quid pro quo, that's a Latin term meaning this or that. You give me this, you get that. The submission to or rejection of sexual attention is made either implicitly or explicitly, a term or condition of employment, or is used to make a basis for an employment decision, like a promotion, continued employment, salary increase, etc. Listed here are a few examples of quid pro quo. An employee is promoted to a promotion, a pay increase, or another job benefit if they agree to a sexual request. An employee is demoted or loses a job benefit for refusing to agree to a sexual request. Quid pro quo normally is a supervisor-subordinate relationship where an employee is forced to choose between giving in to a superior's sexual demands or forfeiting an economic benefit, like a pay increase, promotion, or continued employment. Quid pro quo can be opposite sex or it can be the same sex. A single case of quid pro quo can constitute harassment. The second type of sexual harassment is a hostile work environment. A hostile work environment occurs when unwelcome sexual words or conduct is so pervasive that they unreasonably interfere with an employee's work performance. Its persistent unwelcome sexual conduct create an intimidating, humiliating, or sexually offensive work environment. Some potential behaviors of a hostile work environment, if they're unwelcome, would be brushing against, patting someone, touching their body, maybe making sexual jokes or comments that demean someone due to their sex, whistling, catcalls, making inappropriate gestures to someone, repeated requests for a date after that person has refused. What does it mean to be severe and pervasive behavior? Well, severe is a behavior considered is an activity that alone can be considered harassment even though it's a single occurrence, like touching someone in an inappropriate way. Pervasive means a string of behaviors that individually may not constitute harassment, but it's something that goes on and on for a long period of time. Here's a court ruling from the Federal Supreme Court on sexual harassment. It was called Farragher versus City of Boca Raton, Florida. They had a policy. They provided training to their employees and their supervisors. They forgot to include their seasonal lifeguards. They had a pool. They didn't do their seasonal employees. They didn't talk to them. This lady, Miss Farragher, was harassed by her supervisor. And she told him to quit. He did not stop. She did not know her rights. She did not know what to do, so she went to the EOC. The supervisor and the city were found both guilty. Another court ruling, now this was in the private sector. It was Ellis versus Burlington Northern. Training had been provided to the employees and the supervisors, and they were told how to report. Ms. Ellis failed to use the rights that she had. She did not go to the chain of command. She did not follow up, but she went straight to the EOC. The court ruled against the supervisor, but not the company. Here are the elements that need to be included to have an effective harassment prevention plan. The plan must be in writing. It must define what harassment is. It must declare and talk about what is intolerable. It also must establish a formal complaint procedure. You must provide training. You must have prompt and complete investigation. You must have prompt corrective action and discipline. And you must have a separate retaliation policy required or have as a separate policy. Thanks for joining me today on this presentation about workplace harassment training for supervisors. I hope you realize the seriousness of this and also that you as a supervisor can be held personally liable along with your city and your county.